Welcome everyone in the room and on Zoom. I'd like to begin by acknowledging the traditional custodians on whose lands the Australian National University sits and from whose lands I'm speaking to you today, the Ngunnawal and Ngambri peoples, as well as the traditional custodians of the lands on which each of you are living, working and learning. The First Nations people of Australia have had an intimate relationship with this landscape and the sea country surrounding it for thousands of years. They have met on country to learn and share knowledge, to talk and to listen, and to discuss ideas and solve problems. And they have used that knowledge and those ideas to care for the country and to maintain the relationships between all living things. As we meet here this evening to talk, to share new knowledge, and develop new ideas in the modern law of the sea, we can reflect on and recognise the knowledge and perspectives that Aboriginal people hold in relation to this country. I'd like to pay my respect to the elders of this country, past and present, and to the culture, knowledge, kinship and connection that they hold in relation to country, including the oceans and marine environment that are integral to it. My name is Imogen Saunders. I'm Director of the Centre for International and Public Law here at the Australian National University. And I'm delighted to be here on behalf of CIPL, as we call it, for the launch of Camille's fantastic book, Coastal State Jurisdiction over Living Resources in the Exclusive Economic Zone. Now, my job here tonight is brief. I'm here to welcome you all to ANU and to introduce our wonderful panel of speakers. So first off, welcome all in the room, welcome all online. That's half of it done. Second, to introduce the panel. First, of course, is Dr. Camille Goodman, known, I'm sure, to all of you here in the room. She is a senior lecturer at the Australian National Centre for Ocean Resources and Security, or ANCORS, at the University of Wollongong, a visiting fellow here at the ANU College of Law and at the Sea Power Centre Australia. Before joining ANCORS in 2021, Camille worked at the Commonwealth Attorney General's Department, providing legal and policy advice to the Australian government with a particular focus on the law of the sea and international fisheries law. She came to ANU, we're very lucky to have her here as a Sir Roland Wilson Scholar, to do her PhD, which she completed in 2019. And her first book, the one we are here tonight to celebrate, is the final published form of that PhD, which was published by Oxford University Press in their prestigious series, Oxford Monographs in International Law, in November 2021, which I have realised is actually a year ago, not 3 months ago, as I was thinking when I prepared the comments for this. Now, I am going to get a little personal here because book launches are personal. They're a celebration of something that you've spent so much of your life researching, writing, despairing of sometimes, and ultimately victoriously producing. And Camille is as wonderful a person as she is a scholar, which is to say she is very wonderful at both. And our speakers tonight, as well as being preeminent experts in the law of the sea, also have their own special relationships with Camille, as indeed I do. For my part, I met Camille almost 20 years ago now, when we were both here on campus at ANU, when we were both undergraduate students competing in the Jessup Moot. Myself from West Australia, Camille from Adelaide. And I'm happy to report that 20 years on, we have been bumping into each other ever since and enjoying doing so. So moving on to the rest of the speakers, next to Camille is Sue Robertson, who is First Assistant Secretary of the International Division and Head of the Office of International Law at the Attorney General's Department. Sue has practiced across a spectrum of international law issues, from use of force, international humanitarian law, to trade and investment dispute litigation, but has a special love for the sea and the law of the sea, developed in particular during her role as the legal advisor at Australia's mission to the United Nations in New York, where she was closely involved in the preparatory work for the negotiations on a treaty for biodiversity beyond national jurisdiction. Sue and Camille have worked closely together over the years, including formally as co-directors of the General Advising Section in the Office of International Law, where they shared responsibility for advising on law of the sea issues. Next across is Henry Burmester, who has spent a significant part of his illustrious career advising on law of the sea issues as Senior Legal Advisor to the Australian Government. And when I say illustrious career, let me give you a few highlights. He was member of the Australian delegation for the 3rd United Nations Conference on the Law of the Sea Conference in 1979 to 1980. He worked on fisheries agreements and delimitation negotiations with Papua New Guinea and Indonesia. He appeared as counsel for Australia in the Southern Bluefin tuna and whaling cases, and was an arbitrator in the 2016 Arctic Sunrise arbitration between the Netherlands and Russia. Since retiring from his role as Chief General Counsel of AGS, Henry has kept busy and is appointed as Honorary Professor here at the ANU. Henry and Camille worked together on a range of cases over the years, including on the litigation between Australia and Timor-Leste before the Permanent Court of Arbitration and the International Court of Justice. And finally, on the end is Professor Tim Stevens. Tim is Professor of International Law at the University of Sydney, where his work focuses on the international law of the sea, international environmental law, and international dispute settlement. Tim is the author of a number of leading international law textbooks, or law books, I should say, including The International Law of the Sea, which is currently in preparation for its third edition, along with his co-author, Professor Don Rothwell. Tim is a fellow of the Australian Academy of Law and formerly president of the Australian New Zealand Society of International Law. Tim, like Camille, and like myself actually, is a former PhD student of Don Rothwell. Unfortunately, Don, as Camille's supervisor, cannot be here tonight, but sends his regrets. Camille also worked closely with Tim in the context of the Australian New Zealand Society of International Law, where Camille served as secretary during Tim's presidency. So I'm going to hand over to Sue in just a minute, but before I do, please join me in welcoming Camille and this wonderful panel tonight.
Thank you, Imogen, for that really warm welcome, and thank you to all of you for joining us here and online. I too am delighted to be here to celebrate the official launch of Camille's book. And I think questions about oceans governance, about the management of ocean space, who can regulate it and for what purpose, have never been more important. When we think about the role the ocean plays in providing food for billions of people, in the way the ocean regulates the climate, in the way it provides economic livelihoods for people all around the world. So I think this book really demonstrates the importance that coastal states place on their fisheries management. And it really also shows through state practice the important and innovative ways that states have sought to exercise and protect those resource rights in their EEZ. For me in particular, the Pacific states have demonstrated real creativity, particularly in the way that they have moved to collaboration and coordination between their regional fisheries management organisations and their standards through licensing. And I think that's really demonstrated a move to, I guess, an individual approach to a more collective approach where nations are seeking to protect their fish stocks and also prevent illegal and unregulated and unreporting fishing. So I think a key question that Camille's book places at the heart of the discussion is, have we got this balance right? And it's a really complex, intricate balance that UNCLOS seeks to bring together with a number of tensions. And that balance, of course, is about the rights of coastal states and the rights of flag states, and this broader concept of broader community international interest, I guess, in the management of the environment and in the freedom of navigation. I think we have to think about what the legal and policy consequences are when coastal states claim excessive resource jurisdiction. I just want to say one point about method in this book that really struck me. Camille, you've placed state practice at the heart of this book in a very deep way. Your discipline is really remarkable here. And I think what that example of, I think, over 130 states that you've surveyed has shown, has given a much more in-depth and nuanced approach to how states regulate this crucial area. And it's bringing a much more holistic approach than I think has previously been the case. So I wanted to keep my remarks short because I want to hear from you, and I think all of us do. And Camille, what I think would be good is if you tell us, why did you write this book? Who is it for? And what do you hope will come of this scholarship?
Thank you, Sue, and many thanks also, Imogen, for your lovely welcome and introductions, which set exactly the sort of tone that I feel comfortable with for this event. Thank you. It's a very, very rare thing to have a whole public event dedicated to the discussion of something that you've written. If I'm honest, it's a bit intimidating, but it's an enormous privilege, and so I'm going to make the most of it. And I will focus on your question, Sue. I'll give a short overview of the book from my perspective, and why did I write it? What does it say? And what do I want it to achieve to set the discussion, to set the framework for the panel discussion? I think Sue knows me too well, and she's actually done a lot of the job for me. Why did I write the book? Well, the idea for this book and for my PhD before it, as Imogen mentioned, arose directly from issues that I was seeing in practice in my job then as an international law advisor to the Australian government. And there were really two key things that influenced me, and Sue's actually hit on both of them. First, I was privileged to work closely with fisheries officials from Pacific Island countries over the course of several years. And it really made me think differently about the rights and obligations of coastal states with respect to fisheries in their 200 nautical mile exclusive economic zones, or EEZs. This area in the Western and Central Pacific is the source of half the world's tuna, and more than half of that comes from the waters of Pacific Island countries. So it's really a place of global significance. These countries have small administrations and limited boats, planes and people with which to manage those resources. But by adopting innovative regulations and, as Sue said, by cooperating to apply their coastal state rights collectively, they've multiplied the reach and effectiveness of their jurisdiction and the financial gains from their resources. And at the same time, they've been extraordinarily effective in addressing illegal fishing, which isn't always picked up in the media, which is constantly talking about the problem of illegal fishing, which is not so much a problem in the Pacific. So as a government lawyer for a country with the world's third largest EEZ, I started wondering, what can coastal states actually do as a result of their sovereign rights over living resources in the EEZ? We have a big EEZ with lots of sovereign rights. What can we, Australia, do? Can the success of the Pacific be replicated in other places? At the same time, I started to notice that the law I was seeing in practice, in the laws and policies and day-to-day practice of states, was different to the law I was reading in the books, in judicial decisions and academic writing. And sometimes there were important differences. I thought this was particularly relevant in the law of the sea because our framework convention, the United Nations Convention on the Law of the Sea, is written in that way as a framework. Many of its provisions are general or ambiguous or high level. Much is left for implementation and interpretation through state practice as the convention is put into practice. So there's a key role for states in implementing the provisions of the treaty, and an equally important role for international lawyers and PhD students and academics to review and analyse that practice and arrive at an authentic interpretation of the treaty. But reviewing state practice is time-consuming and difficult. It can be hard to find. It's difficult to interpret. It isn't all in English. So it's more common to simply interpret the words of the treaty in light of their object and purpose, without actually referring to what states are doing in practice. But as I was seeing, this approach can lead to a gap between the law in the books and the law in practice, or indeed to two different understandings of the law. So I decided to look at the actual practice of states, as many states as possible, in fact 145, so that other academics and courts and tribunals and governments would have access to a study that incorporates all of this practice and would have the option to make a decision based not just on their interpretation of a text sitting at their desk, but on the subsequent practice of states in actually implementing that text. So what does the book do? Well, it seeks to establish the contemporary extent of the jurisdiction that can be exercised by coastal states on the basis of their sovereign rights over living resources in the EEZ. And to answer this question, It does examine the usual range of sources, the provisions of UNCLOS, judicial decisions and academic writing, but it also looks at how those provisions have been implemented in practice. And this examination is framed around 5 key issues, which to me represent the key aspects of coastal state jurisdiction. First, there's a threshold question. What is fishing? Some of you have heard me talk about this for about 5 or 6 years now, so excuse me if I do it again, but UNCLOS doesn't actually define fishing, and the judicial decisions and academic writing don't necessarily define it either. The fishing industry has changed enormously over the last 40 years. So in order to understand the vessels and the actors and the activities that coastal states can regulate, it's critical to understand what actually constitutes fishing. Not just the practice of catching fish, but a massive range of associated activities that go with it. Second, it looks at the exercise of prescriptive jurisdiction, which is the right of coastal states to make and apply laws based on their sovereign rights over living resources. In this aspect, I focus primarily on how coastal states regulate access to living resources in the EEZ by foreign vessels and foreign nationals, and particularly the innovative range of rules, regulations, prerequisites and conditions that they can apply to such access. Third, I look at enforcement jurisdiction. Once you have these laws, how do you enforce them? Including through boarding and inspection, arrest and judicial proceedings, all of which are envisaged in UNCLOS, also by some eye-wateringly high financial penalties, and by other means, including sinking vessels, blacklisting, even whitelisting. Fourth, I consider how coastal states regulate the transit of unlicensed foreign fishing vessels through the EEZ, and this is my favourite chapter. By that I mean foreign fishing vessels which are not fishing or which say they are not fishing in the EEZ, but are merely passing through under the freedom of navigation. These vessels fall in a sort of grey area between the freedom of navigation and the coastal state's sovereign rights over living resources. But there's a real risk that such vessels will engage in illegal fishing. But it's traditionally been very difficult for coastal states to regulate them without being accused of infringing the freedom of navigation. But there's a lot of interesting practice on this point. And finally, I look at the hot pursuit of fishing vessels beyond the EEZ. Hot pursuit is a right which arises where a foreign vessel has violated the coastal state's laws and essentially fled the scene of the crime. And it has some very specific and in some ways quite outdated procedural requirements which have to be fulfilled by the coastal state in order for the hot pursuit to be valid. And this poses some challenges and some opportunities for innovation for coastal states in the context of modern fisheries enforcement. What does the book find? Well, generally speaking, I don't want to disappoint you, but with some exceptions, while coastal states have in some areas departed from the exact terms of UNCLOS, I found that where there are limitations on their jurisdiction, they generally address this by finding alternative approaches that still respect the general jurisdictional framework under the convention. For example, while UNCLOS prohibits imprisonment as a penalty for illegal foreign fishing in the EEZ, states have been able to circumvent this prohibition by obtaining consent from the flag state or the state of nationality of the offender before imposing the penalty. So there are ways around some of these things. And of course, UNCLOS is ambiguous enough that even though not all the practice of states is directly envisaged in the convention, it's often more a question of developing or adding detail to the convention than derogating or departing from it. There are also some key themes in the state practice. I would say there are 4 key ways in which coastal states maximise the extent of their jurisdiction on the basis of sovereign rights over living resources in the EEZ. First, they use expanded interpretations of jurisdiction to thicken the substance of their rights within the EEZ. So for an example, I could give you the definition of fishing in the fisheries laws of many states, which doesn't relate, as I said, just to the catching of fish, but to a broader range now of fishing-related activities. All the ancillary operations that form part of modern industrial fishing: processing, packaging, storing, transporting, transshipping, refuelling fishing vessels at sea, resupplying with water, food, fuel, fishing gear, rotation of personnel, and conduct of repairs at sea. You can see how this broad definition of fishing starts to thicken or expand the substance of the coastal state's jurisdiction, the things they can regulate in the EEZ. Second, coastal states use their prescriptive jurisdiction to make laws with extended spatial or geographic effect in order to influence activity beyond the EEZ. For example, in the Pacific, the parties to the Nauru Agreement, or the PNA, require that for the duration of their licence, any foreign vessel that is licensed to fish in the EEZ of a PNA member must not engage in fishing or some of those fishing-related activities in certain areas of the high seas. So essentially, these coastal states are leveraging their sovereign rights within the EEZ to address issues that would otherwise be beyond the geographic scope of their jurisdiction. Third, and also most evidently in the Pacific, coastal states can increase the scope and application of their jurisdiction by cooperating with other coastal states, including through the collective application of licensing conditions and through the cooperative enforcement of fisheries laws. And fourth, coastal states increasingly employ modern technology to enhance the reach and effectiveness of their jurisdiction. And that's particularly evident in the enforcement context, with an ever-increasing range of techniques and technologies for the remote detection of fisheries offences using aerial and space-based mechanisms, even satellites, rather than the difficult, dangerous and costly physical inspections at sea. And I think, interestingly, we increasingly see that as a collaboration between civil society and private sector, such as Global Fishing Watch, and Sea Shepherd also conducting patrols on behalf of coastal states. So finally, the impact I would like the book to have. Given my research origin story, you can probably guess at the sort of impact I would like it to have, or the purpose I would like it to serve. First, I'd like it to be a resource for practitioners, many of you here tonight, or the people you're training to come after you, for government lawyers and fisheries officials and policymakers, and even for civil society. I'd love governments to look at the examples in the book of what other states are doing and say, have we used our fisheries jurisdiction in the best way possible? Is there a more effective way to design our laws and policies? Would that idea work for us? Second, I hope it will be a useful reference for courts and tribunals. In my view, courts and tribunals have not historically paid sufficient attention to state practice when they've been called upon to make decisions about rights and obligations under UNCLOS. Obviously, it's not easy for judges to undertake this sort of global review themselves every time a case comes before them, not in the sort of timeframes we'd like decisions in anyway. But hopefully, if a reference of this sort was available, they might feel they could turn to it, even if they didn't put a footnote. Third, I hope that it is also useful for academics, as researchers, as teachers, and as students, whether in terms of the methodology, which might be drawn on for other studies, or in terms of the conclusions about the contemporary law of the sea, or even perhaps some of the general international law issues. To try and make it as helpful as possible for all of these people, I've summarised the state practice in an accessible and usable way, I hope, in tables that summarise legislation region by region and country by country, down to the section and paragraph number of legislation. So I hope that makes it possible for other people to find it, and also to let me know if I got it wrong. And every internet link in the book is preserved in an online internet archive called the Wayback Machine. So even if the links break over time, as they inevitably do, and as laws and policies get updated, you can still see what I was looking at when I wrote the book. I think that's enough reflections from me, Sue, and I'm very keen to hear Tim and Henry's.
Henry, can I start with you? Would you share with us what your key takeaway from the book was? And I'm also interested to hear whether there was any surprises for you in some of the state practice.
I guess the key takeaway for me was just the richness of state practice and the way in which the fisheries provisions have developed in 40 years, from when I went to Law of the Sea conferences when we were negotiating that text that's in the Law of the Sea. It's the world's changed dramatically, and so there is this whole wealth of new practice. But it reminded me a bit of a constitution. We say UNCLOS is the constitution for the oceans, and in a sense, that's what it's proved to be. The constitution is there with the basic conceptual architecture and some detailed provisions, which may or may not be able to be worked around. But in a sense, what's happened is the states have taken that constitution and filled it in and developed it and evolved. And it's a tremendous story. I commend the book to anyone. It really is an outstanding piece of international law scholarship, but it's easy to read and exciting to read. I certainly found that. So it sort of reminded me of a constitutional law text that doesn't just annotate the words of the Constitution, which when you go to so many Law of the Sea books, they just look at Articles 61, 62, 56 and try and make sense of it. But in a sense, what we have here is the constitutional law that has developed in 40 years in relation to Law of the Sea. And I suppose what I was surprised about was just how much it had developed. But what also reassured me was that in a sense, Camille wasn't saying it was completely off the planet and didn't fit at all in the Law of the Sea framework. In fact, it was a quite understandable evolution of the Law of the Sea once it's put in the tremendous structural way in which Camille has put it.
Hard act to follow, Henry, given his storied history in the Law of the Sea. Can I first say, it's a great pleasure to be here. It's a great pleasure to be invited to this event. And aren't book launches really special, celebratory occasions? I mean, we, as academics and as practitioners, I think we're often accustomed to kind of rough and tumble events where we might be put on the spot, but not at book launches. Book launches are where we can celebrate the author and certainly not put you on the spot too much, other than the spotlight in a pleasant way. So well done, Camille. Someone ought to have brought a bottle of champagne to be whacked against the book to launch it into the sea. So in terms of the question around the key point or reflection that I took away from the book, well, I think it confirmed for me once again that the EEZ is the most enigmatic of the maritime zones recognised or established by the UN Convention on the Law of the Sea, and that ambiguities and uncertainties regarding the character of the EEZ and the jurisdictional rights that it confers can only be resolved by the careful study of state practice of the kind that Dr. Goodman has embarked on here. I think Camille summarises really elegantly the nature of coastal state jurisdiction over fisheries in the EEZ as being, quote, a broad discretion constrained by functional limits, which are determined on the basis of reasonableness and by reference to the balance of interest reflected in the EEZ regime. There's a lot in that sentence, but it captures really very elegantly all core aspects of Camille's thesis. There are several really striking aspects of Camille's analysis. For me, one of the most impressive is the way that she charts a path between competing conceptions of the EEZ, shining a light on age-old concepts of dominium and imperium, and giving them new life and meaning by reference to contemporary practice. My own PhD supervisor for a while, the late and great Ivan Shearer, always said that if something can be expressed in Latin in international law, it must be true, and it's good advice, and Camille liberally uses it appropriately. Now, Camille makes the point that while some states and some commentators assimilate the notion of sovereign rights to sovereignty, suggesting that it's only a matter of time before the EEZ resembles the territorial sea, and others make the converse claim that the living resources of the EEZ are amenable only to stewardship rather than ownership, Camille takes us right back to the essential characteristics of the EEZ as agreed at the Third UN Conference on the Law of the Sea. The exclusivity of coastal states in the living resources of the EEZ are functional. It's not a spatial jurisdiction that accompany these rights. So just finally, I'd say in relation to state practice, I'd echo what Henry and Sue have said. Very, very impressive. If you look at the list of tables, 7 extraordinary tables. So the first surprise is just the volume of state practice that Camille has managed to survey. It's extraordinary. The second striking thing is just the variety of that state practice, and that variety is not necessarily a bad thing, that the variety exists within this reasonable margin of appreciation, falling within the scope of rights conferred on coastal states. And Camille also makes the point that irrespective of what some of the state practice indicates in terms of prescriptive jurisdiction on the law books, coastal states have been very careful not to overstep the mark when it comes to enforcement, and she explores some of that restraint as well. Oh, sorry.
Thanks very much, Tim. I think you've talked about some of the limitations of court and tribunal jurisprudence, Camille. Henry, I'm wondering whether you could just reflect on some of the court approaches, broadly speaking, obviously in the short time we've got available, but just any reflections you have on the approaches that courts and tribunals have taken to EEZ regulation and some of the limitations of those.
Well, when I read the book, I was in a sense surprised how many cases Camille had found, because as she said, there's very few opportunities for cases that directly raise fishing issues to come before courts and tribunals. So in a sense, many of the cases referred to are related issues, but not directly on fishing itself, and yet you can draw from them broader principles. And when I first read the book, I thought, these are pretty hopeless decisions. There's very few good ones amongst them. And I think Camille alluded to some of the problems, that they're made in a bit of an information vacuum. They don't have a book like this with all the state practice in front of them. The parties don't necessarily do a good job in terms of the presentation of arguments and research and so on. Often the time limits don't allow if they're dealing with prompt release of vessels and things like that. And so I thought, I think state practice is a lot more important in this area than court and tribunal decisions. On the other hand, they do add to the rich fabric, which needs to be taken into account. I mean, there's one decision that seems particularly wrong, where they don't understand the basis of jurisdiction. The old North Star case. And that enables me to say something about jurisdiction, because jurisdiction is central in Camille's book. And I can remember when she first started work on this, talking about the Lotus case energetically to me. And I was thinking, really, is there much in Lotus? As a government lawyer, I've tended to treat it as a bit of a carte blanche to do whatever you can get away with. And Camille's probably corrected me, I think, with her analysis. But she starts with Lotus and the whole fundamental notion of jurisdiction. And let me say, as a government international lawyer, sovereignty, territory, jurisdiction, you can't escape the basic concepts of international law. And in a sense, that informs so much of the work you get asked about. And it certainly informs this book. And it enables Camille to put everything in context and point to the balancing of interests and the scope of jurisdiction and how things fit together. And I think that's what some of the tribunal decisions have lacked. They haven't had the depth of knowledge, the opportunity to get the knowledge. Maybe the composition of some of the tribunals hasn't been as good. I mean, the Law of the Sea Tribunal has so many judges, and yet they seem on some of these issues to be quite bitterly divided. Like there's strong dissents by quite respectable judges and not necessarily unanimity. So I found it quite interesting to have the cases discussed and mentioned, but I put my money on state practice, I must say.
Yes, it strikes me that this is very much a book with general international law and law of the sea within that larger framework. And I think that's why it will also be extremely useful for students, because you unpack a lot of really important general international law principles as a way of understanding and analysing problems. And I think you've said to me on more than one occasion you want it to be more than a specialist text, and I think it definitely is. And it really shows, I think, your experience being an advisor in our time in oil together, when we cover those broad principles of general international law. Tim, I want to return to your comment about the enigmatic nature of the EZ. Given your interest in the environment, sustainability, could you say something about where you think we've got to with the role of the EZ in protecting resources and the environment more broadly?
Yeah, sure. So Camille made a reference to broader community concerns to some extent in her remarks, as did you as well, Sue. And this goes to the characteristic of the EEZ as being both, it's really balancing three interests, isn't it? It's really balancing coastal state interests, flag state interests, or other states generally, and then global kind of collective interests of a community character in relation to sustainable management. And so that means that if we think historically, the EEZ was in part an enclosure of global commons to advance sustainability objectives, to avoid the so-called tragedy of the commons, by apportioning to coastal states primary responsibility and exclusive responsibility, let's be honest, but that responsibility is to some extent exercised as an agent, in terms of an agency relationship almost, on behalf of the international community as a whole, in service of some of the conservation objectives that are set out in the convention. And that certainly comes through in Camille's analysis. And also, I think the reference to regional instruments like the Nauru, the P&A arrangement, fascinating, because that's a consensual grouping of states that have decided to achieve not just national kind of interests or priorities, but truly regional concerns around both resource management and environmental sustainability. I could go on and perhaps talk about marine protected areas as well, because this is the other kind of great new horizon for the EZ. To what extent can states start exercising greater restraint in the EZ? How far can environmental protections be pushed? Because as scholars of the EZ will know, and there's lots in this room, the EZ is meant to be open to other states to access, surplus fish stocks if not used by the coastal state. What if coastal states just decide, well, we're going to close our EZ completely to fishing? Raises some really interesting issues from a then potentially even kind of food security point of view. So yeah, lots of tensions and issues there. Can I just come back briefly and talk about courts and tribunals? Henry makes a really good point here. And it's interesting, speaking as someone who teaches a lot of law of the sea and writes a fair bit of it, we do, don't we? We rush to decisions and we assume that they provide all the answers, but they provide actually only just part of the answer. And the state practice is so much more important. And this discussion has got me thinking about how we might improve judicial decision-making in the law of the sea context, but perhaps international law more generally. And perhaps part of the problem is our problem as common lawyers with the adversarial system, with judges just wanting to decide the narrow list or controversy between them, not wanting to go through the sheer variety of state practice. And does that possibly mean that the Part 15 system is not living up to the promise as something that would hold the package deal together, would avoid unilateral interpretations, would promote a consistent and effective operation of the convention? Anyway, that's a big question, perhaps for another day.
Can I jump on that?
It's your launch.
No, I like this topic, and for me, this discussion ends up in thinking about this EZ and more broadly the law of the sea as a 3 or 4 dimensional sort of system. So the coastal state is weighing its own rights and obligations. So the coastal state is doing a balance for itself between, its rights to exploit resources and its obligations to conserve the marine environment. And then other states are also doing their own weighing between their rights to have freedom of navigation and their obligations to exercise flag state control and what have you. And then those two things have to balance between each other and exercise due regard for each other's rights and obligations, which have already been balanced. And then there's a community interest that you have to add on as well to balance. So the whole of UNCLOS is about balancing rights and interests. But when we go to court, we usually have two parties who are just arguing for one right or one interest and no representation of the community interest. So I agree with you, Henry, that it's important to be able to go to decisions for a synthesis of the law, but at the same time, it's not necessarily serving the purpose. Yeah.
Overall, as you've explained, Camille, and Tim's touched on, the book seems relatively comfortable with where state practice ends up in terms of this thickening jurisdiction, Camille. My sense was that that within the ambiguities that exist in the EEZ and the way that states use consent and collaboration, that these don't undermine in any concerning way for you this intricate balance of UNCLOS. But I'm just wondering, Tim and Henry, do you have any concerns about the thickening of coastal state jurisdiction and those pushing the boundaries of enforcement, particularly for things like freedom of navigation, or that's something that concerns you less as well?
It didn't particularly concern me. I thought where Camille ended up was really sort of quite reasonable. She says that the fears that the EEZ would turn into a territorial sea that some writers had suggested hasn't really come to fruition. There is still this balance, and as she analyses, and she just referred to all this balancing of what's reasonable, proportional, due regard. There's so many qualifying words. It is often hard to say something is clearly in or outside the rules unless you know all the context and consider the broader picture. But so I suppose the fact that there is these, we might have pushed the boundaries that people might have originally envisaged in relation to resources, but it's certainly not a territorial sea. I didn't get the sense that that's what's happening. And even Tim's reference to some of the marine environment, I think there is still a recognition. There will be tests, there will be competing considerations, but as we have a better understanding of how resources are linked to everything else in the marine environment, then maybe that will help explain or enable states to understand how they can regulate other things consistently with having due regard to the rights and freedom of navigation and other states. So that's my sort of response.
And I completely agree. So those of us working in the law of the sea constantly confront the anxiety of so-called creeping jurisdiction, that coastal states will push ever more further from the baseline with ever greater assertions of jurisdiction until we get to, complete dominion over a 200 nautical mile zone. And that has not come to pass. And certainly Camille argues basically in relation to fisheries that to the extent that there's been creeping jurisdiction, it has been perfectly, well, not perfectly, but largely within appropriate functional limits. So states have, they have thickened the jurisdictional claims that they've made, but that's within certain functional boundaries. And that's different from the kinds of creeping jurisdiction that might have a general subject matter character. So states, for instance, asserting a general security jurisdiction in the EEZ, which would be contrary to the UN Convention, or perhaps a spatial based jurisdiction in terms of saying we can control customs matters within the EEZ, and we know that has been refused pretty clearly by the tribunal. So I think Camille's diagnosis is actually, when it comes to fisheries at least, there's no cause to panic. There's no enormous reason for alarm.
I think we might see if we've got any questions from our participants, either in the audience or online. I might perhaps start with online. Let me just have a look.
Oh, there's a hand up.
Oh, we've got a hand up. You can, I can't see who that is.
Genevieve.
Oh, Genevieve. Hi. Genevieve, do you want to unmute yourself and ask your question in person or virtually?
Thanks very much, Sue. I'm speaking to you from the unceded land and sea country of the Dharawal people. Dr. Goodman, firstly, I really want to thank you for such a comprehensive study of coastal state jurisdiction and the EEZ. It's worldwide and world class, and probably like many in the audience, I'm sure I'm intrigued to learn what comes next for this body of scholarship.
Thanks, Genevieve. Actually, I'm looking directly at Anthea Roberts, and I'm thinking about how she always tells me that by the time she promotes one of her books, she's bored of it. That's not actually the case for me, because I don't have that students. But there are some things that I would like to write more about with the perspective and rules that I've sort of been able to deduce in this book. So I'd like to look at how coastal states use their jurisdiction for some other things. So in particular, within the context of fisheries, I think it's timely to think about labour rights. And I'd just like to have a look at what coastal states might be able to do to address problems of forced labour on fishing vessels. And I think another important issue for coastal states to regulate is emissions. How are fishing vessels in their waters being regulated in terms of emissions? Beyond that, originally my PhD, and some here may recall, was supposed to be about fisheries and oil and gas, about coastal state sovereign rights broadly in the EZ. That turned out to be too much quite fast. So these days I'm no longer interested in oil and gas, but I am interested in other areas of coastal state jurisdiction, and I really want to write more about how this jurisdiction applies in relation to renewable energy. When we get beyond oil and gas, what does the EZ and the law of the sea look like? So that's my current preoccupation. Thank you for that question, Genevieve.
Anthea.
In defense.
Yeah.
So thank you. Thank you. It's lovely to be here, by the way. I have a question and a comment, and they're both about general and consistent practice. So the question is, one of the things that I think is really remarkable about this book, and everyone's brought this up, is your approach to state practice, because of course you're meant to find general and consistent practice, but nobody does, right? So you've done something that everybody says they're meant to do, but nobody ever does. And I wonder if you have done something to abstract from the particulars of this case to work out kind of what was your methodology that allowed you to do it, but also what did it let you see, or what would you not see if you didn't do it, in a way that's abstracted from the particular case that you could explain to a broader community of international lawyers, because I think you're motivated to speak to a broader community of international lawyers and you have something to share, but it would need to be done in a slightly more abstracted way, I think, that draws on your example, but pushes it as a methodology. That's the question. Have you done that? Will you do that? Can you do that? And the comment on general and consistent practice is, you and I were writing, I met you while you were writing this book, and when you and I were both writing a book at the same time. I have never seen anyone write a book in the way that you wrote this book. I have never seen a PhD student have such a general and consistent approach. You literally had like a certain amount that you would write every day, and you actually did it. And I've just wanted to say, if there is a methodology that you could also capture that and communicate to other students, it seemed that you managed to get through with remarkably fewer mental health concerns and remarkably higher productivity than is often the case.
Thank you, Anthea. I did suggest to Imogen that Anthea shouldn't be allowed to ask questions. Well, I'll take the first question first. Actually, Frances Angadi, who's here tonight, and I talk about this a lot because Frances uses a similar methodology to me in her work in terms of looking at state practice. And she's also looking at the law of the sea. And we talk about, when she's finished, getting together and perhaps finding another person and looking at what our work might tell us for treaty interpretation generally, and for, is the VCLT approach working when you interpret the law of the sea, because we'll have more data across different examples. Beyond that, I suppose what I would say is I asked open-ended questions. I wasn't looking for the wrong thing or the right thing. I was just looking for what a state's doing. I tried to, for each area of practice, I had a template that I applied to every state with questions where I would look for examples of how did they regulate this particular issue? What was fishing for that state? And I'd have to look at, was there a different fishing vessel, support vessel? Like, you look widely to sort of answer the question. So it was a pretty open-ended methodology, which is not fast, I suppose. I'd have to think more about how to abstract that for other groups, but I think we have a good starting point, at least in terms of multiple studies on law of the sea, looking at state practice to see what that tells us about maybe what we're missing from the broader discussion if we don't do it. In terms of my personal method, deep-seated fear. My method is to try and write 500 words a day, and usually you can beat 500 words a day, and then you feel really good about yourself. And I was so fortunate. I was supported financially by a very generous scholarship from the Sir Roland Wilson Foundation and the Attorney General's Department. I had great supervision. I had everything that a PhD student could ask to have, really, in terms of having the right environment and I had a clear question that had plenty of time to germinate, and people to ask. So I was extraordinarily lucky. Yeah.
Thanks, Sue, and thanks, Camille. Congratulations. We miss you in the Office of International Law, but I can confirm that your book has pride of place. Indeed, I think several copies in our shelves. I wanted to ask you a question about what your work tells us about treaty making, and sort of two reflections. One, what does your survey of state practice tell us, if anything, about non-parties to UNCLOS and their attitude to the EEZ, or more broadly? And if, as Henry has outlined, UNCLOS really has worked as a constitution, and reflecting on your finding that there's been creativity and adaptation, but largely compliance with the grand bargain, what can we learn from UNCLOS in other treaty making processes as those who go on and try and negotiate new agreements in new contexts? What does success look like? What does UNCLOS teach us about that?
What a great question. I feel quite unqualified to answer it. On the first part of the question about non-parties and practice, I think I was lucky that I was looking at a relatively stable part of the Law of the Sea Convention. I wasn't looking at state practice in relation to maritime military activities in the EZ, or military surveys, or some of those things where the practice would be more divergent. I think that we owe a lot to the people who negotiated this convention, and without having really thought about it terribly hard, I think the time that they had to do it was probably really important. And I get a bit nervous when, especially civil society is putting a lot of pressure on the current BB&J negotiations. Every time that it's not adopted, they say they've failed again, and governments won't adopt it. And I think maybe they're just trying to get it right. Fixing it later is way more difficult. I actually think in many ways the areas that are less specific are more successful. Areas of great specificity, like requiring notices to stop to be given by an audio or visual signal at a distance that enables it to be seen or heard, they don't have such longevity as broader provisions that are more easily interpreted as time and technology changes. So I think
Pirate radio.
Pirate radio.
And of course, some of those detailed provisions came from the 1958 conventions and were just reproduced. But even hot pursuit, in the Arctic Sunrise case, we at least tried to make it a bit more up to date. But in response to Jessie's question, I mean, I do think I sort of, when I talked about it as a constitution and what that means, I think that is one distinguishing feature. I was thinking, well, the UN Charter's in a similar category, but so many other conventions, A, they don't have as many state parties, they're not universal, they don't set out to be constitutions, they go down into the detail and specific rules. And so I do think it's a bit of a unique convention in that sense, but I mean, there may be other big multilateral treaties around where maybe some of the law of war treaties, I don't know, but yeah, it does strike me as maybe a special category just because of the nature of it, the number of parties and the number of issues it deals with.
We've got a question from Luciana online. Would you like to take yourself off mute and ask your question?
Hello, can you hear me?
Yes.
Hello, Camille. Very well done. Congratulations on your book launch. We have been in contact already. I'm speaking from Sweden. And first a comment, as you know, I'm also working with state practice with a very ambitious number of countries. And every time I'm lacking energy and I think that I'm doing something that is completely crazy and very ambitious, I remember of your research and your books, and your book comes to mind as a good source of inspiration. And my question today is about the sources of state practice. As we all know, they are not defined. State practice can come from various sources. So I'd like to know your process of defining which were the sources that you used to find the state practice. How did you set the boundaries, and how did you analyze opposition to state practice? Some countries are doing their practices are in a way, but they feel, or countries are opposing to it. So which were the sources for each one of the two cases, and how did you dealt with practices that are not agreed by the entire community as a practice that could be accepted? Thank you in advance.
Thanks, Luciana. That's a great question. And I'm really looking forward to reading your work. I think many people here will be looking forward to that on marine scientific research. I suppose in a way I treated it a bit like a literature review. You know, with a literature review, you don't quite know when you're done until you stop finding new things. Maybe that's not the right way to do it. I'm not sure. But, so because I was looking at essentially activity beyond territory, I wanted a legislative basis for it. Because mostly when you're acting beyond territory, you need some sort of legislative basis to do so, some power. So my primary approach was to look for legislation. And in the fisheries context, I was very grateful to have the FAO Lex database, which has a lot of fisheries laws in it, but not as many as one might wish. And given the obligation in UNCLOS to give due notice of your fisheries laws, I think it would behove countries to be a bit better about sharing the legislation, perhaps even translating it. That could go for us as well, I'm sure. And actually, for those who are doing this sort of work, using a Chrome browser with Google Translate and finding HTML websites where the whole website translates into English is the best way to go about this in a fast fashion. But beyond legislation, I trawled databases looking for judicial decisions. I find Twitter to be a fantastic source of information just for keeping up with who's been arrested or what cases might have been prosecuted or who was arrested but couldn't be prosecuted, and that sort of state practice that gives a bit of flavour to it. And if I found something that I was uncomfortable about, for example, South Africa's requirement that fishing vessels seek an authorisation to enter the EZ, I looked extra hard to see if that was really what I thought it was, and see if vessels were being prosecuted, and see if any of their flag states were protesting. And I can confirm that none of them were. So I tried to confirm it wherever I could, but I would also look for press statements, basically very wide, never-ending desktop research. And I also have some wonderful colleagues who I sent things to and said, I think this is how this works. You speak Indonesian, is this how it works? So grateful to sort of the network of people who help with that.
We're going to bring your microphone in.
In the years of my involvement in international law as a public lawyer, but as director of CIPL, I was very conscious as also editor, co-editor of the Yearbook of International Law, the state practice section. So the follow-up to that, to your response is, how much did you look at yearbooks of international law around the world for your state practice analysis?
Yeah, great question, Kim. Probably not as much as I should have. I looked at our yearbook. A lot of other yearbooks, I'm not sure if their state practice sections are as good as ours. I'll just put it that way.
Thank you very much, and for all of the discussion. This is just a very quick response to what was said about state practice and how it's recorded. And as DFAT does the annual record for the yearbook, if there's any sense that it's not providing what it should be, or if there's some way that we can change that, we're all ears. So it's a difficult job every year. We get someone very good onto it. It takes a very long time, and this is as much a question for academics and other users as it is for you. But
thanks, Michael. I'll prepare my list of questions.
Frances Angadi.
Thanks so much. So lovely to be here, Camille. Congratulations. And it's just so wonderful to be here and to feel all this love from everyone in the room and online to support you in this event. For my own part, I feel like we've been talking law of the sea for a fair while now, so it's wonderful to have had those conversations. I wanted to say that yes, as a doctoral student now studying under Tim's supervision, your work is absolutely a resource for me and for others. In Law of the Sea, although I'm looking at a different aspect, but also other things which others have mentioned, for example, the relationship between treaty and custom, which is a particularly thorny one in the Law of the Sea context. Camille's work really offers some insights into how to examine that complex relationship and how state practice fits into that particular question. So thank you for that. And I guess as many have heard, Tim has mentioned the extensive documentary trail, which is contained within the book, and Camille has outlined that method. That's really just an example of the generosity that Camille brings to all of her scholarship, not just obviously to anyone who may be wanting to engage with this work, but also for all of us who've interacted with Camille throughout this work. It reflects her broader generosity of intellectual spirit, curiosity, and invitation for all of us to be part of your conversation. So thank you so much for including us in this. Can I ask a last question? Which is, do you think that the UNCLOS system is able to meet some of these challenges that you've identified? So you've said, for example, you're interested in thinking about, how the EEZ regime is going to stand up to regulating emissions or dealing with offshore energy. So this three-dimensional balance of rights that you've identified, is it up to that task? I'll leave that to you.
Thanks, Frances. Frances and I call ourselves Orthodox radicals, and if anyone wants to know more about that, you can ask us at drinks. Thank you for those really, really generous comments. I think it is. I think, to me, UNCLOS and the jurisdiction in UNCLOS is on a continuum. It's not static. It doesn't sit in one place. It moves. The emphasis at one point might be on combating illegal fishing, and coastal states might need a bit more, room to move in order to do that. But at another time, it might be on I don't even know, protecting the marine environment, and maybe everybody's accepting some greater standards. I think it can move. I think the framework that we have has proved robust for 40 years. I think we can be innovative. I'm interested to see what the BBNJ agreement brings beyond BBNJ, what it brings for other issues as well. I read some really great student essays this week about whether ocean acidification should be regulated through the BBNJ agreement. So I look forward to the potential of that. But I think we can look forward confidently.
Thank you. Well, we're going to draw this discussion to a close. So thank you very much. Rich questions both from the people online and in the audience, and tonight me and Tim. And it just leaves Camille to do the final vote of thanks.
Thank you, Sue. And I had to make a list because I have a lot of people to thank for the last 7 years. This has been, I started my PhD in 2015. I applied for it in 2014. And I think it, you know, they say PhD is a lonely journey, and it wasn't for me, but it does take a village to write a book or a PhD. And I was lucky to have an amazing village, and a lot of you are here tonight. I'd like to acknowledge the Sir Roland Wilson Foundation, who support scholarships for public servants like me to do research on issues of public policy, and they raise the profile of evidence-based policy making. And I think it's been shown here tonight that that's really important, having the space and time to do that sort of work. It's not easy in the academy to get that sort of privilege. So it's such an important program, and Rebecca and Sally Ann are here tonight. Thank you. The Attorney General's Department, particularly Chris Moratis, John Reid, Sue, many people who are here tonight who I've worked with and who saw me through my PhD and supported both my PhD and actually the preparation of the book with a visiting fellowship. My PhD supervisors, none of whom are here tonight, unfortunately, but all of whom contributed in their own way to this. Professor Don Rothwell, Associate Professor Sarah Heathcote, who pushed me really hard on some of those general international law issues and made it a much better product. And Professor Rob McLaughlin, who's now one of my colleagues at ANCORS. And the ANU College of Law for having me here, including as a visiting fellow. Anthea, who very generously introduced me to her contacts at OUP, which gave me the chance to be published in this series. My colleagues at ANCORS, many of whom are online tonight. I'm sorry that this was in Canberra, not in Wollongong, but thank you for joining and for welcoming me into the Academy and putting up with my constant references to in government. And finally to Sue, Tim and Henry for reading 350 pages and for describing it in a much more eloquent way than I think it was ever written. Apparently I charted a course and I did some things that I hadn't realised. So thank you so much. And all of you for coming online and in person. I know I've attended a lot of events from online the last couple of years, so thank you very much for joining. I hope that you felt as present as you could, and let's have some drinks.